Good morning, everyone. Today we are going to discuss about the judiciary. So many times courts are seen only as arbitrators in disputes between the individuals or the private parties, but judiciary performs some political functions also. Judiciary is an important organ of the government, and the Supreme Court of India is in fact one of the very powerful courts in the world. Right from 1950, the judiciary has played an important role in interpreting and in protecting the constitution. In this chapter, you will study the role and importance of the judiciary. In the chapter on the fundamental right, in this chapter, you will read on the fundamental rights. You have already read that the judiciary is a very important for protecting our rights. After studying this chapter, you would be able to understand the meaning of independence of judiciary, the role of Indian judiciary in protecting our rights, the role of the judiciary in interpreting the constitution, and the relationship between the judiciary and the parliament of the India. Now, here you can see this cartoon. As an eminent lawyer, you ought to know that your action is tantamount to under section B, subsection G, V, IX, and read along with the IPCA XIB नोट विद द स्टैंडिंग. सॉरी, यहाँ पे मैंने जो है गलत चीज़ें पढ़ दी, ठीक है, लेकिन अभी जो है नो फिस्टिकप्स प्लीज़, दिस इज़ रूल ऑफ लॉ. ये कोर्ट है, ठीक है, और यहाँ पे लॉयर है, जज है, ये सारी चीज़ें दिखाई गई हैं. आर के लक्ष्मण इन द टाइम्स ऑफ इंडिया, ये कोर्ट कार्टून या फिर जो भी कंटेंट है वो लिया जाता है. उसके बाद नाउ नेक्स्ट इज ये मतलब इंपॉर्टेंट थिंग फ्रॉम हियर, व्हाई डू वी नीड एन इंडिपेंडेंट जुडिशरी? In any society, disputes are bound to arise between the individuals, between the groups, and between the individuals or the groups and the governments. All such disputes must be settled by an independent body in accordance with the principle of rule of law. This idea of rule of law implies that all the individuals, rich and poor, men or women, forward or backward castes, are subjected to the same law. This principal role of the judiciary is to protect rule of law and ensure the supremacy of the law. It safeguards rights of the individual, settles disputes in accordance with the law, and ensures that democracy does not give way to individual or group dictatorship. In order to be able to all this, it is necessary that the judiciary is independent of the political pressures of any political process, political pressures. And what is meant by an independent judiciary? How is this independence ensured? Independence of judiciary, simply stated, independence of judiciary means that the other organs of the government, like the executive and the legislature, must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The other organs of the government should not interfere with the decision of the judiciary. Now, judges must be able to perform their functions without fear or favor. Independence of the judiciary does not imply arbitrations or absence of accountability. Judiciary is a part of the democratic political structure of the country. It is therefore accountable to the constitution, to the democratic traditions, and to the people of the country. I remember the case of the Machal mentioned in the chapter 2. Don't they say justice delayed is justice denied? Somebody should do something about this. Now, how can the independence of judiciary be provided and protected? The Indian constitution has ensured the independence of the judiciary through a number of measures. The legislature is not involved in the process of appointment of judges. Thus, it was believed that party politics would not play a role in the process of appointments. In order to be appointed as a judge, a person must have experience as a lawyer and or must be well versed in the law. Political opinions of the person or his or her political loyalty should not be the criteria for appointments to the judiciary. The judges have a fixed tenure. They hold office till reaching the age of retirement. Only in exceptional cases judges may be removed, but otherwise they have security of tenure. Security of tenure ensures that the judges could function without fear or fear. The constitution prescribes a very difficult procedure for the removal of judges. The constitution makers believed that a difficult procedure of removal would provide security of office to the members of judiciary. The judiciary is not financially dependent on either the executive or legislature. The constitution provides the salaries and allowances of the judges are not subjected to the approval of the legislature. The actions and the decisions of the judges are immune from the personal criticisms. The judiciary has the power to penalize those who are found guilty of contempt of court. This authority of the court is seen as an effective protection to the judges from the unfair criticisms. Parliament cannot discuss the conduct of the judges except when the proceedings to remove a judge is being carried out, and this gives the judiciary independence to abdicate without fear of being criticized. ना उसके बाद जो यहाँ पे है क्या दे रखी है, एक्टिविटी दे रखी है. होल्ड अ डिबेट इन द क्लास ऑन द फॉलोइंग टॉपिक. सो विच ऑफ द फॉलोइंग फैक्टर्स डू यू थिंक work as a constraints over the judges in the giving their rulings? Do you think these are the justified? Constitution, precedents, opinion of the other courts, public opinion, media, traditions of law, laws, and time and staff constraints, fear of public criticisms, fear of action by the executive. Here I am afraid I am getting confused. In a democracy you can criticize the prime minister or even the president but not the judges. And what is this contempt of court? But am I being guilty of contempt if I asked about these matters? Now, appointment of judges. The appointment of judges has never been free from the political controversy. It is a part of the political process. It makes difference who serves in the Supreme Court and High Court. A difference in how the Constitution is interpreted, and the political philosophy of the judges. Their views about the active and assertive judiciary or controlled and committed judiciary have an impact on the fate of the legislations enacted. Council of Ministers, governments, and chief ministers and chief justice of India all influence the process of judicial appointment. As far as the appointment of the chief justice of India (CJI) is concerned, over the years, a convention had developed whereby the senior most judges of the Supreme Court was appointed as the Chief Justice of India. This convention was, however, broken twice. In 1973, A.N. Ray was appointed as a CJI, superseding three senior judges. Again, Justice M.H. Beg was appointed, superseding Justice H.R. Khanna, 1975. उसके बाद जो next है क्या है? But I think finally the Council of Ministers would have greater say in appointing the judges, or is that the judiciary is a self-appointing body? The other judges of the Supreme Court and the High Court are appointed by the President after consulting the Chief Justice of India. This in fact meant that the final decisions in the matters of the appointment rested with the Council of Ministers. What then was the status of the consultation with the Chief Justice? This matter comes up before the Supreme Court again and again between 1982 and 1998. Initially, the court felt that the role of the Chief Justice was purely consultative, and then it took the view that the opinion of the Chief Justice must be followed by the President. Finally, the Supreme Court has come up with a novel procedure, and it has suggested that the Chief Justice should recommend names of the persons to be appointed in the consultation with the four senior most judges of the court. Thus, the Supreme Court has established the principle of the collegiality in making the recommendations for the appointments. At the moment, therefore, in the matters of appointment, the decision of the group of the senior judges of the Supreme Court carries in the making the देखो यहाँ पे है thus the Supreme Court has established the principle of collegiality in making recommendations for appointments. At the moment, therefore, in the matters of appointment, the decision of the group of the senior judges of the Supreme Court carries greater weight. Thus, in matters of the appointments to the judiciary, the Supreme Court and the Council of Ministers plays an important role. Now, removal of the judges. The removal of judges of the Supreme Court and the High Court is also extremely difficult. A judge of the Supreme Court or High Court can be removed only on the ground of the proven misbehavior or incapacity. A motion containing the charges against the judges must be approved by the special majority in both the houses of the parliament. Do you remember what special majority means? We have studied this in this chapter on the elections. It is clear from this procedure that removal of a judge is a very difficult procedure, and unless there is a general consensus among the members of the parliament, a judge cannot be removed. It should also be noted that while in the making appointments, the executive plays a crucial role. The legislature has the powers of removal. This has ensured both balance of the power and independence of the judiciary. So far, only one case of removal of a judge of the Supreme Court came up for the considerations before the parliament. In that case, though the motion got 2/3 majority, it did not have the support of the majority of the total strength of the house, and therefore the judge was not removed. Now, unsuccessful attempt to remove a judge. In 1991, the first ever motion to remove a Supreme Court justice was signed by 108 members of the parliament, and Justice V. Ramaswamy during his tenure as the Chief Justice of the Punjab and Haryana High Court was accused of misappropriating funds. In 1992, a year after parliament had started the removal of proceedings, a high-profile inquiry commission consisting of judges of the Supreme Court found Justice V. Ramaswamy guilty of willful and gross misuses of the office and moral turpitude by using the public funds for the private purposes and reckless disregard of the statutory rules. While serving as the Chief Justice of the Punjab and Haryana High Court, despite this strong indictment, Ramaswamy survived the parliamentary motion recommending removal, and the motion recommending his removal got the required two-thirds majority among the members who were presented and voting. But the Congress party abstained from the voting in the House. Therefore, the motion could not get the support of the one half of the total strength of the House. Now, here check your progress. Why is the independence of the judiciary important? Do you think that executive should have the power to appoint the judges? If you were asked to make the suggestions for changing the procedure of appointing judges, what changes would you suggest? Now here next is a structure of the judiciary. So the Constitution of India provides for a single integrated judiciary system. This means that unlike some other federal countries of the world, India does not have separate states courts, and the structure of the judiciary in India is pyramidal, with the Supreme Court at the top and high courts below them, and district and subordinate courts at the lowest level. And the lower courts functions under the direct superintendence of the higher courts. Now here Supreme Court of India, its decisions are binding on all the courts, can transfer judges of the high courts, can move cases from any court to itself, can transfer cases from one high court to the another. Now, High Court can hear appeals from the lower courts, can issue writs for restoring the fundamental rights, can deal with the cases within the jurisdiction of the states, exercises the superintendence and control over the courts below it. Now, district courts deals with the cases arising in the districts, considers appeals on the decisions given by the lower courts, decides cases involving serious criminal offences. Subordinate courts considers cases of civil and criminal nature. Now, here jurisdiction of the Supreme Court. So the Supreme Court of India is one of the very powerful courts anywhere in the world. However, it functions within the limitations imposed by the Constitution. The functions and the responsibilities of the Supreme Court are defined by the Constitution, and the Supreme Court has specific jurisdiction or scope of powers. Now, jurisdiction of the Supreme Court of India. Original settles disputes between union and the states and amongst states. Appellate tries appeals from lower courts in the civil, criminal and constitutional cases. Advisory advises the president on the matters of the public importance and laws. Appellate में जो है special powers, can grant special leave to an appeal from any judgment or matter passed by any court in the territory of India. Now here यहाँ पे writ जो है ये जो है ना jurisdiction of the Supreme Court of India, writ can issue writs of the habeas corpus mandamus, prohibition, certiorari and quo warranto to protect the fundamental rights of the individual. Now next is here next is here original jurisdiction. So in original jurisdiction means cases that can be directly considered by the Supreme Court without going to the lower courts. Before that, from the diagram above, you will notice that cases involving federal relations go directly to the Supreme Court, and the original jurisdiction of the Supreme Court establishes it as umpire in all disputes regarding the federal matters. In any federal country, legal disputes are bound to arise between the union and the states and among the states themselves. The power to resolve such cases is entrusted to the Supreme Court of India. It is called as original jurisdiction because the Supreme Court alone has the power to deal with such cases. Neither the high courts nor the lower courts can deal with such cases. In this capacity, the Supreme Court not just settles dispute but also interprets the powers of the union and the state government as laid down in the Constitution. Now next is writ jurisdiction. As we have already studied in this chapter on the fundamental rights, any individual whose fundamental rights has been violated can directly move the Supreme Court for the remedy, and the Supreme Court can give the special orders in the form of writs, and the High Court can also issue the writs. But the person whose rights are violated have the choice of either approaching the High Court or approaching the Supreme Court directly. Through such writs, the court can give orders to the executive to act or not to act in a particular way. Appellate jurisdiction. The Supreme Court is the highest court of appeal. A person can appeal to the Supreme Court against the decisions of the High Court. However, High Court must certify that the case is fit for the appeal, that is to say that it involves a serious matter of interpretation of law or constitution. In addition, in criminal cases, if the lower court has sentenced a person to death, then an appeal can be made to the High Court or Supreme Court. Of course, the Supreme Court holds the powers to decide whether to admit appeals even when appeals is not allowed by the High Court. Appellate jurisdiction means that the Supreme Court will reconsider the case and the legal issues involved in it. If the court thinks that the law or the constitution has a different meaning from what the lower courts understood, then the Supreme Court will change the ruling, and along with that also gives new interpretation of the provision involved. The high courts too have appellate jurisdiction over the decisions given by the courts below. Advisory jurisdiction में क्या है? In addition to original and appellate jurisdiction, the Supreme Court of India possesses advisory jurisdiction also. This means that the President of India can refer any matter that is of public importance or that which involves interpretation of Constitution to the Supreme Court of advice. However, the Supreme Court is not bound to give the advice on such matters, and the President is not bound to accept such an advice. What then is the utility of the advisory powers of the Supreme Court? The utility is twofold. In the first place, it allows the government to seek the legal opinion on a matter of importance before taking action on it. This may prevent unnecessary litigations later. And secondly, in the light of the advice of the Supreme Court, the government can make suitable changes in its actions or legislation. Article 137 ये क्या कहता है? The Supreme Court shall have power to review any judgment pronounced or order made by it. Article 144 क्या कहता है? All authorities, civil and judicial in the territory of India shall act in the aid of the Supreme Court. उसके बाद जो नेक्स्ट है ये क्या है? ये कार्टून क्या सोच रही है? Why is the Supreme Court allowed to change its own ruling? It is because courts can also make mistakes. Is it possible that the same judges is part of the bench that revises the ruling and was also on the bench that gave the ruling in the first place? Now here, read these articles quoted above जो कि अभी मैंने बताए थे. These articles help us to understand the unified nature of our judiciary and the powers of the Supreme Court. Decisions made by the Supreme Court are binding on all the other courts within the territory of India. Orders passed by it are enforceable throughout the length and breadth of the country, and the Supreme Court itself is not bound by its decisions and can at any time review it. Besides, if there is case contempt of the Supreme Court, there is a case of contempt of the Supreme Court, then the Supreme Court itself decides such a case. Now here match करना है तो जो है मैच करने के लिए दे रखा है कि डिस्प्यूट्स बिटवीन स्टेट ऑफ बिहार एंड यूनियन ऑफ इंडिया विल बी हर्ड बाय किसके द्वारा जो है ये सुना जाएगा सुप्रीम कोर्ट के द्वारा अपील फ्रॉम द डिस्ट्रिक्ट कोर्ट ऑफ हरियाणा विल गो टू डिस्ट्रिक्ट कोर्ट की अपील जो है वो कहाँ पे जाएगी ये सारे ऑप्शंस दे रखे हैं फिर सिंगल इंटीग्रेटेड जुडिशरी जो है वो कौन सी है फिर डिक्लेयरिंग लॉ अनकॉन्स्टिट्यूशनल जो है वो कौन सा है इस तरीके से चीज़ें दे रखी हैं मैच करने के लिए उसके बाद जो नेक्स्ट है वो है जुडिशियल एक्टिविज्म हैव यू हर्ड ऑफ द टर्म जुडिशियल एक्टिविज्म और पब्लिक इंटरेस्ट लिटिगेशन both these terms are often used in the discussions about the judiciary in the recent times. Many people think that these two things have revolutionized the functioning of the judiciary and made it more people friendly. नाउ यहाँ पे देखो डाक हड़ताल कोर्ट ने हस्तक्षेप किया ऑर्डर 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 इस तरीके से चीज़ें दे रखी हैं इरफान ने बनाया हुआ है कार्टून एंड डू यू नो दैट इन द रिसेंट टाइम्स द जुडिशरी हैज़ रूल्ड दैट बांस एंड हड़ताल्स आर इलीगल्स उसके बाद जो नेक्स्ट है वो क्या है नेक्स्ट है द चीफ इंस्ट्रूमेंट थ्रू द विच जुडिशियल एक्टिविज्म हैज़ फ्लरिश्ड इन इंडिया इज पब्लिक इंटरेस्ट लिटिगेशन PIL और सोशल एक्शन लिटिगेशन SAL. What is PIL or SAL? How and when did it emerge? And in normal course of law, an individual can approach the courts only if he or she has been personally aggrieved, and that is to say a person whose rights have been violated or who is involved in a dispute could move the court of law. This concept underwent a change around 1979. In 1979, the court set the trend when it decided to hear a case where the case was filed not by the aggrieved persons but by the others on their behalf. As this case involved a consideration of an issue of public interest, it and such other cases came to be known as public interest litigations. Around the same time, the Supreme Court also took up the case about rights of prisoners, and this opened the gates for the large number of cases where public spirited citizens and voluntary organizations sought judicial intervention for the protection of existing rights, betterment of life conditions of the poor, protection of the environment, and many other issues in the interest of the public. A PIL has become the most important vehicle of judicial activism. Now, judiciary, which is an institution that traditionally confined to responding to the cases brought before it, began considering many cases merely on the basis of newspaper reports and postal complaints received by the court. Therefore, the term judicial activism became the more popular description of the role of the judiciary. Here, यहाँ पे एक कार्टून क्या सोच रहा है? I have heard someone say that PIL means private interest litigation. Why would that be so? Now, some early PILs. In 1979, newspaper published reports about the under trials, and there were many prisoners in Bihar who had spent long years in jail, longer than what they would have spent if they had been punished for the offences for which they were arrested. This report promoted This report prompted an advocate to file a petition. So this report prompted an advocate to file a petition. The Supreme Court heard this case. It became famous as one of the early public interest litigation. I am in hurry, that's why I cannot explain in Hindi. थोड़ी सी देर में मेरी जो है क्लास होएंगी स्कूल की, ठीक है, तो मुझे जाना है. This was the Hossein Khatun versus Bihar case. In 1918, a prisoner inmate in 1980 in 1980 क्या हुआ था? A prison inmate of the Tihar jail managed to send a scribbled piece of paper to the Justice Krishna Iyer of the Supreme Court, narrating physical torture of the prisoners, and the judge got it converted into a petition. Though later on the court abandoned the practice of considering letters, this case, known as Sunil Batra versus Delhi Administration 1980, also became one of the pioneers of the public interest litigation. Through the PIL, the court has expanded the idea of the rights: clean air, unpolluted water, decent living, etc., are rights for the entire society. Therefore, it was felt by the courts that individuals as parts of the society must have the right to seek justice. To justice wherever such rights were violated. Secondly, through the PIL and judicial activism of the post 1980 period, the judiciary has also shown readiness to take into consideration rights of those sections who cannot easily approach the courts. For this purpose, the judiciary allowed public spirited citizens, social organizations, and lawyers to file the petitions on the behalf of the needy and the deprived. It must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court, and they need a different kind of judicial approach. If we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental rights. Justice Bhagwati in Bandhua Mukti Morcha versus Union of India 1984. Activity में क्या given है यहाँ पे? Find out the details about at least one case involving as a public interest litigation and study the way in which that case helped in serving the public interest. Judicial activism has had manifold impact on the political system. It has democratized the judicial system by giving not just to the individuals but also groups access to the courts. It has forced executive accountability. It has also made an attempt to make the electoral system much more free and fair. The court asked candidates contesting elections to file the affidavits indicating their assets and income along with the educational qualifications so that the people could elect their representatives based on the accurate knowledge. There is, however, a negative side to the large number of PIL, that is public interest litigations, and the idea of proactive judiciary. In the first place, it has overburdened the court. Secondly, judicial activism has blurred the line of the distinction between the executive and the legislature on the one hand and the judiciary on the other, and the court has been involved in resolving questions which belong to the executive. Now, I think judicial activism is more about telling the legislature and the executive what they should do. What will happen if the legislature or the executive started giving justice? Thus, for instance, reducing air or sound pollution or investigating cases of corruption or bringing about electoral reforms is not exactly the duty of the judiciary. These are the matters to be handled by the administration under the supervisions of the legislatures, and therefore some people feel that judicial activism has made the balance among the three organs of the government very delicate. Democratic government is based on each organ of the government respecting the powers and jurisdiction of the others. Judicial activism may be creating strains on this democratic principle. Now you are the judge. A group of citizens from a city have approached the court through a PIL asking for an order to the city municipal authorities to remove the slums and beautify the cities in order to attract the investors to the city. They argue that this is in the public interest, and the residents of the slum localities have responded by saying that this will encroach on their right to life, and they argue that right to life is more central to the public interest than the right to a clean city. Imagine that you are the judge, right? A judgment deciding if the public interest litigation involves public interest. Now, judiciary and rights. We have already seen that the judiciary is entrusted with the task of the protecting rights of the individuals. The Constitution provides two ways in which the Supreme Court can remedy the violation of the rights. First, it can restore the fundamental rights by issuing the writs of habeas corpus, mandamus, etc. Article 32. The High Courts also have the power to issue such writs. Article 226. Secondly, the Supreme Court can declare the concerned law as the unconstitutional and therefore non-operational. Article number 13. Uske baad, together, these two provisions of the Constitution establish the Supreme Court as the protector of the fundamental rights of the citizens on the one hand and the interpreter of the constitution on the other. The second of the two ways mentioned above involves judicial review. Perhaps the most important power of the Supreme Court is the power of the judicial review. Judicial review means the power of the Supreme Court or high courts to examine the constitutionality of any law if the court arrives at the conclusion that the law is inconsistent. The provision of the constitution such a law is declared as unconstitutional and inapplicable. The term judicial review is nowhere mentioned in the constitution. However, the fact that India has a written constitution and the Supreme Court has struck down a law that goes against the fundamental rights implicitly gives the Supreme Court the power of judicial review. Besides, as we show in the section or jurisdiction of the Supreme Court, in the case of the federal relations too, the Supreme Court can use the review powers if a law is inconsistent with the distribution of powers laid down by the Constitution. Suppose the central government makes a law which, according to the some states, concern the subject from the state list, then the states can go to the Supreme Court, and if the court agrees with them, it would declare that the law is unconstitutional. In this sense, the review power of the Supreme Court includes the power to review legislations on the ground that they violate the fundamental rights or on the grounds that they violate the federal distribution of the powers. The review power extends to the laws passed by the state legislature also. Together, the writ powers and the review power of the court make judiciary very powerful. In particular, the review power means that the judiciary can interpret the constitution and the laws passed by the legislature. Many people think that this feature enables the judiciary to protect the constitution effectively and also to protect the rights of the citizens, and the practice of the entertaining PIL has further added to the powers of the judiciary in protecting the rights of the citizens. Now next is here did you know that the practice of public interest litigation is now becoming more and more acceptable in many other countries, while many courts across the world, particularly in the South Asia and Africa, practice some form of the judicial activism comparable to that of the Indian judiciary. The Constitution of South Africa has incorporated public interest litigation in its Bill of Rights. Thus, in the South Africa, it is a fundamental right of the citizen to bring before the Constitutional Court cases of violation of the other person's rights. नाउ नेक्स्ट मतलब इसका जो रिमेनिंग थिंग्स है वो चलो पढ़ ही लेती हूँ. इसमें क्या है कि डू यू रिमेंबर दैट इन द चैप्टर ऑन द राइट्स वी मेंशन द राइट अगेंस्ट द एक्सप्लोटेशन. दिस राइट्स प्रोहिबिट्स फोर्स्ड लेबर, ट्रेड इन द ह्यूमन फ्लैश एंड प्रोहिबिट्स एम्प्लॉयमेंट ऑफ द चिल्ड्रन इन द hazardous jobs. But the question is, how could those whose rights were violated approach to the court? Public interest litigation and judicial activism made it possible for the courts to consider these violations. Thus, the court considered a whole set of cases: the blinding of the jail inmates by the police, inhuman working conditions in the stone quarries, and sexual exploitation of the children, and so on. This trend has made rights really meaningful for the poor and disadvantaged sections. Check your progress. When does the court use the review powers? What is the difference between the judicial review and writ? Judiciary and parliament. Apart from taking a very active stand on the matters of rights, the court has been active in seeking to prevent the subversion of the Constitution through the political practice. Thus, areas that were considered beyond the scope of the judicial review, such as powers of the president and governor, were brought under the purview of the courts. Now, there are many other instances in which the Supreme Court actively involves itself in the administration of justice by giving directions to the executive agencies. Thus, it gave directions to the CBI to initiate investigations against the politicians and bureaucrats in the Hawala case and the Narsimha Rao case, illegal allotments of the petrol pumps cases, etc. You may have heard about some of these cases. Many of these instances are the products of the judicial activism. The Indian Constitution is based on the delicate principle of the limited separation of the powers and checks and balances. This means that each organs of the government has a clear area of the functioning, and thus the parliament is supreme in making laws and amending the constitution. The executive is supreme in implementing them, while the judiciary is the supreme in settling or disputes and deciding whether the laws that have been made are in accordance with the provisions of the constitution. Despite such clear-cut division of the power, the conflict between the parliament and judiciary and executive and the judiciary has remained a recurrent theme in the Indian politics. We have already mentioned the differences that emerged between the parliament and the judiciary over the rights to property and the parliament's power to amend the constitution. Let us recapitulate that briefly. Immediately after the implementation of the constitution began, in controversy arose over the parliament's power to restrict right to property, and the parliament wanted to put some restrictions on the right to hold property so that land reforms could be implemented. The court held that parliament cannot thus restrict fundamental rights. The parliament then tried to amend this constitution, but the court said that even though an amendment, a fundamental right cannot be abridged. The following issues were at the center of the controversy because the parliament and the judiciary: what is the scope of the right to private property? What is the scope of the parliament's power to curtail, abridge or abrogate fundamental rights? What is the scope of the parliament's power to amend the constitution? Can the parliament make laws and that abridge fundamental rights while enforcing directive principles? उसके बाद जो नेक्स्ट है वो क्या है? नेक्स्ट जो है वो ये है यहाँ पे While there can be no two opinions on the need of the maintenance of the judicial independence, it is also necessary to keep in view one important principle: the doctrine of the independence is not to be raised to the level of a dogma, so as to enable the judiciary to function as a kind of the super legislature or super executive. The judiciary is there to interpret the constitution or abdicate upon the rights. Alladi Krishna Swami Iyer, 23 November 1949. During this period, 1967 and 1973, this controversy became serious. Apart from the land reforms laws enforcing the preventing detention laws, governing reservations in the jobs regulations, acquiring private property for the public purposes, and law deciding the compensation for such acquisition of private property were some instances of the conflict between the legislatures and the judiciary. In 1973, the Supreme Court gave a decision that has become very important in regulating the relations between the parliament and the judiciary. Since then, this case is famous as the Keswananda Bharti case. In this case, the court ruled that there is a basic structure of the constitution, and nobody not even the parliament through the amendment can violate the basic structure. And the court did do more things. First, it said that the right to property, the dispute issue, was not part of the basic structure, and therefore could be suitably abridged. Secondly, the court reserved to itself the right to decide whether various matters are parts of the basic structure of the constitution. This case is perhaps the best example of how judiciary uses its power to interpret the constitution. This ruling has changed the nature of the conflicts and between the legislatures and the judiciary. As we studied earlier, the right to property was taken away from the list of the fundamental rights in 1979, and this also helped in changing the nature of the relationships between the two organs of the government. Some issues still remain a bone of the contention between the two. Can the judiciary intervene in and regulate the functioning of the legislatures in the parliamentary system? The legislation has the power to govern itself and regulate the behavior of its members. Thus, the legislature can punish a person who the legislatures hold guilty of breaching privileges of the legislature. Can a person who is held guilty for the breach of the parliamentary privileges seek protection of the courts? Can a member of the legislature against whom the legislature has taken disciplinary action get protection from the court? And these issues are unresolved and are matters of the potential conflict between the two. Similarly, the constitution provides that the conduct of the judges cannot be discussed in the parliament. These have been several instances where the parliament and state legislature have cast aspersions on the functioning of the judiciary. Similarly, the judiciary too has criticized the legislatures and issued instructions to the legislatures about the conduct of the legislative business. The legislature says that as violating the principle of parliamentary sovereignty. These issues indicate how delicate the balance between any two organs of the government is, and how important it is for each organ of the government in a democracy to respect the authority of the others. Now check your progress. The main issues in the conflict between the judiciary and the parliament have been appointment of the judges, salaries and allowances of the judges, scope of parliament's power to amend this constitution, interference by the parliament in the functioning of the judiciary. Now here यहाँ पे जो है conclusion दिया गया है. Conclusion हम बाद में देखेंगे. एक बार ये देख लो कार्टून क्या है. कार्टून में क्या है? At last I have been honorably acquitted. It was a nightmare of this time. I swear I will never go again indulge in the corruption. How active is the judiciary in trying to curb the corruption in the public life? ये क्या है? लीगल सर्विस डे 2018. ठीक है, तो ये भी हम बाद में देखेंगे एक बार. Thank you so much for watching and stay connected.